Welcome, welcome, welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast, and a big hello to everyone in between. As you can see on the screen, my name is Dan Balkaran, and I'll be your employment lawyer for the next 30 minutes, answering all your questions about all things employment law. Again, as you can see on the screen, I am a lawyer at Samfiru, Tumarkin, LLP, which, as always, is Canada's leading employee side employment law firm. Okay, before we get started, housekeeping notes. As always, if you wish to get a hold of us, you can do so at employmentlawyer.ca. As you can see on the screen, help@employmentlawyer.ca and 1-855-821-5900. We have some questions already in. If you can, actually only one question in. Please send your questions in if you have them as soon as possible. I'd like to get to all of them before the end of the show. Okay, let's get started. Nero asks, sorry, one second. Apologies. Nero asks, my contract includes a very aggressive non-compete clause. I work as a game developer, and I'm wondering if I am in one of those industries that non-competes are heavily enforced for. Can I negotiate with my employer if I need to leave my position? Okay, well, so everything is negotiable. I'll say that non-compete clauses are, I don't want to use the word presumptively unenforceable, but generally that's the way it goes. So think of, let's look at it this way. If let's just say you work at a widget company for 20 years and all you know how to do is manufacture widgets, and that's all you've got in terms of your skills, manufacture widgets, and you have a contract that says you can't go work for anyone else. You also have a mortgage and 2 kids, okay, that are relying upon you to feed them, and you are terminated. And your contract says, well, you can't go work for anybody else for a period of 24 months. And now you're prevented from doing the only thing you know how to do, which is make widgets. And so what the effect of that non-compete clause would be is that you will not be able to work making widgets, which means you won't be able to earn the same money you were making before, which means you will not potentially be able to pay your mortgage and feed your family. That's not really in society's best interest. So generally, non-compete clauses will be unenforceable for those reasons. Now, they can be enforceable in very narrow circumstances. One, they have to be narrowly contained in terms of geographic scope. All of Canada and North America is not gonna work out. Within a 20-kilometer radius of a specific city might, but it also has to be temporally confined to have a chance of being enforceable. So, 2 years probably, maybe that'll work, but less has a greater chance. 6 months has a much better chance. And then and what you're competing against has to be narrowly defined as well. If it's just all products and services offered by company X, company ABC, probably not. So if these things are narrowly defined, it has a better chance of being enforceable. But even then, to be enforceable, non-compete clause, and when I say enforceable, I mean a court will side with the company against you with respect to whether or not that non-compete clause actually limits you from working for another employer for that period of time. But even then, if you're just a regular rank and file employee, not in possession of any trade secrets for the business, probably still not enforceable, or it's less likely, again, for the widget problem that we just talked about, where you got to feed your family and pay your mortgage, and those things are in society's best interest. So, you do have insider knowledge and trade secrets, and it's much more likely than that the non-compete clause is going to be enforceable. But generally, they presumptively aren't enforceable. very narrow circumstances, they are. If you are a regular rank and file video game developer, maybe not. But the challenge for you is, if you, so let's just say you leave your current company and you go work for another company. And if your current company then sends a letter to you and to your new company saying, hey, you're not permitted to work for this company because of the non-compete clause, and we're going to sue you for any losses arising from same, that really gets you off on the wrong foot with the new company. So it can do a lot of damage. Now, generally in such situations, that doesn't occur. There might be a threatening letter or two, but in terms of an actual lawsuit, it's unlikely because there has to be actual loss. And so when you do go and work for another company that is perhaps competitive with your existing company, it's incumbent upon you to make sure that you are not sharing confidential information or proprietary information of your old employer or your current employer with your new employer, because then there could actually be a loss, and that loss could result in a viable claim against you and or your new company. So in the event that you go work for a competitor, it's unlikely to be enforceable, but you can greatly assist it in there not being really any teeth to any claim by your former employer by ring fencing all of your old company knowledge and not sharing it and any confidential information you might have with the new employer. Now, it's not a guarantee they won't bother you. The old employer won't bother you and the new employer about potentially violating the non-compete, but it really makes it more likely that it would just, it won't amount to anything. So certainly lots of things to think about. I would suggest that before you make a move, you have a conversation with a seasoned employment lawyer about that, and make sure that I shouldn't say make sure, but get an opinion about the actual specifics of your non-compete clause and the likelihood that it's enforceable. And if it is enforceable, what your potential avenues are. So I'll leave it there, but you can always get a hold of us, employmentlawyer.ca, helpemploymentlawyer.ca, 1-855-821-5900. Okay. I am not going to identify this person because it's a unique name, so I'll just call them M. Do you always get time and a half if you work a stat holiday? Can an employer refuse to pay a different rate, or are there certain positions that would be exempt from stat holiday pay? Okay, so your entitlement to time and a half on statutory holidays will be enshrined if you're provincially regulated in the Employment Standards Act of your jurisdiction. I can't speak for all jurisdictions, but most likely it is time and a half for those particular days. The employer is bound by that unless there are certain exceptions for your position as set out in the particular Employment Standards Act. Certain positions exempt from stat holiday pay, yes. So professions, accountants, architects, lawyers, doctors, anyone qualified as exception under where the ESA the Employment Standards Act doesn't apply to them. Under in BC, it's the Employment Standards Regulation. It's probably different in every location or in every provincial jurisdiction, but yes, each jurisdiction will have some professions that are exempt from applicability of the Employment Standards Act and or potentially certain sections of the Employment Standards Act that deal with minimum pay on statutory holidays. So you'll have to check your local Employment Standards Act to find out the specifics of your question for you and your jurisdiction. But generally, all the Employment Standards Act or Standards Acts are very, they're easy for non-lawyers to read. And in fact, often provincial governments, I know in BC, the Employment Standards Branch has loads of non-lawyer friendly material that can answer questions like that very easily. So online. Okay, question from Lee. If an employer offers me an amount that is lower than what your calculator says, what should I do? Okay, so unsaid in Lee's question is that Lee has been terminated from his employment and he or she is negotiating some sort of severance package. And so the calculator that he's referring to is my firm's severance calculator, which gives an estimate based on your age, length of service, position, availability of similar employment, what you are potentially entitled to in severance. You can go to on the screen, pocketemploymentlawyer.ca, and you can see what our calculator has to say. Now, our calculator is not a substitute for legal advice. It doesn't take into account what your employment contract says. It doesn't take into account other potential contingencies, reductions, deductions that can apply in certain factual situations, and all of which inform any risk on your particular claim, and therefore what the corporation or your former company is prepared to pay you. And so what the calculator does is sort of give a best day range if all things break your way, but it is not a substitute for legal advice. And so, Lee, if you're stuck on a tremendous difference in value, like if our calculator says you get 12 months and they're at 8 weeks, I think you need to talk to a lawyer right away. And if you're talking about a minor difference, maybe you can negotiate it out. But if you're talking about a major difference, you need to talk to a lawyer. And again, if you want to talk to us, you can do so. Employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. I would just say, Lee, think of it as a best day guide, not a guarantee. It's just a guide in terms of, if everything breaks your way, then this is what a rough estimate of what you could get is. But there's lots of variability, lots of play in the joints of reasonable notice. And certainly judges retain ultimate discretion in terms of what the quantum can be. So certainly you're going to want to get legal advice on that particular question. Again, if it's far apart, if it's close, if you guys are close, then, and calculator says 12 months and they're at 10 months, it's probably something you can just settle out on your own. But again, if we're at 12 months and, calculator says 12 months and your company won't go past, 8 to 10 weeks, yeah, you should get legal advice. Okay, question from, I don't even know, NT. I've been on maternity leave for a year and notified my human resources department and manager that I would like to extend it for another month. After informing them of this, I was told my benefits would not continue past the original date. Is this allowed? Well, yeah, because you are on a leave, and so you have to take a look at what your contract says and what your local Employment Standards Act says. But if you're on a leave, I don't think there's a requirement of there's a certain amount of pay, maternity leave pay, that comes from the government, federal government, and then quite often your employer will top it up to some degree. But I don't believe there's any requirement. And I'm open to being wrong about this. It's not a question I've ever thought about, but I don't believe there's any requirement from your employer to extend your benefits or to even have you on benefits through a period of time where you were unable to work. And so I think it is at their discretion, but subject to what your local Employment Standards Act says and what your contract says. So do you have any sort of legal recourse here? Probably not. But again, check what your contract says. I don't think they have an obligation to extend your benefits into your maternity leave. Although again, it's not a question I've ever thought about. So, certainly I could be wrong about it, but that's just my impression of that particular question. But no, I don't really think you have anything to go on there. And it's 1 month of benefits. What's that? $300, something like that. I don't think it's personally worth upsetting the apple cart if you're returning to work as normal with no issues going back to your role after maternity leave, which does not always happen. They're quite often, I see it, once a month. Someone goes on maternity leave, tries to come back to work, and employer says, "Oh, we don't have your job anymore." And the reason why is they gave your job to somebody else. So if you're able to come back with no issue, that's what you're legally entitled to. But it's a win, and I wouldn't get overly worried about a few $100s in benefits if that's the situation. So okay, M has another question. Partner just received a note that they're closing their branch and gave everyone working notice to the end of July. I'm sorry to hear that. I don't see your question, though. Yeah, there's no question in here. Oh, here we go. If anyone leaves before the end of the working notice period, then they will consider it a resignation and they won't be owed anything. Is the notice to the end of the month enough for a 4-year employee? They said it's more than the minimum of the Employment Standards Act. Okay, so this is a really interesting question. So when your employer can terminate your employment at any time without cause by providing you with the legal amount of notice you're required to be provided. Okay, and just a little note here. So notice is just a heads up. It's like, hey, the bad news is we're going to terminate you in 4 weeks. The good news is we'll give you time off during that period of time to look for a job. Hopefully you're not unemployed for very long, if at all. That's all you're entitled to. However, if you've got 4 weeks of notice coming to you and your employer terminates you today, you're still entitled to those 4 weeks. You just can't get it as working notice, so it converts into money that you get without having to work it. That's called severance, right? So if your employer terminates you today or some point before the end of the notice period, whatever is left on the other side of the notice period is money that you get, okay? So to answer your question, so notice and severance are interchangeable as far as the math calculation is concerned, but your legal entitlement only is to notice, to the heads up that we're going to terminate you in the future. Okay, so your question, there's 4 weeks of working notice. Is that enough? Okay. Well, there's two types of notice. There's small notice and big notice. Okay. And sorry. Yeah, I'll just call it those two. So small notice is statutory, comes from the Employment Standards Act. It's roughly 1 week per year of service to a maximum of 8 weeks. That's what your partner's company is talking about. Here's the statutory minimums, or slightly more. So it sounds like he was there for slightly under 4 years. So that's what they're giving. They're giving 4 weeks. Okay. So is that enough? Well, it depends. So there's, like I said, there's two types of notice. There's small severance, 1 week per year of service to a maximum of 8 weeks or more or less, and big severance or big notice, which is 1 month per roughly. It's not quite like that, but 1 month per year of service to a maximum of 24 months. That's just a rough guide, but it's a good place to start. Okay. So obviously you want to be in the big one. What determines that? Your employment contract. If you signed if your partner signed a valid employment contract that he freely agreed to that legally limits him to the small notice, that's all he gets. Okay. So the existence of the employment contract and what it says is everything. If he never signed one, he automatically gets the big notice. Okay. And what's the big notice? Depends on his age, length of service, position, and how long, what industry he's in, how long it's going to take him to get a new job. And so, it could be that if he's been there for 4 years, might have as much as, say, 6 months coming to him, depending on the situation, depending on whether or not he signed an employment contract that limits him to the small severance. So in order to evaluate that particular question, you should probably speak to an employment lawyer as soon as possible. And again, if you want to speak to us, you can do so. employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. It's not necessarily a small amount of money. Like the more money your partner was making, the difference between 4 weeks and 4 or 5 months can be substantial, right? So certainly you want to get that question investigated, but and you certainly don't want to sign a release until you have a chance to talk to an employment lawyer. Okay. Question from Ishan. I wanted to understand the principle of day in lieu. I think you mean pay in lieu. How do I need to take it within a certain time? Oh, maybe you mean day in lieu. Within a certain time, is it paid up to termination? I don't understand your question, Ishan. Like, pay in lieu is pay in lieu of notice. Day in lieu sounds like where you're getting a vacation day in lieu of something. Quite often businesses will do that, like they won't pay overtime and they'll just hand you vacation days. It's a way to get extra work done without having to approve overtime. I know I used to all the time do when I used to run before I was a lawyer, I used to run call centers for major technology corporations, and I would do that all the time. I would give out free, because I had discretion to do that, but not necessarily to give people extra pay. And so you'll find that happens a lot. I think that's might be what you're talking about, Sean, but I have no idea. You have to please articulate your question if you can a little more clearly before the end of this broadcast. Marta asks, starting a return to work from a medical leave, employer gave notice that my position is being eliminated at the end of August, and I would be extended on extended leave until then. Is that allowed? No, they can't just extend your leave. Only you can extend your leave. What can I do? You need to talk to an employment lawyer right away. If it were me and you came across my desk, I would probably, it depends on what your employment contract says. If your employment contract limits you to small severance, it may change the strategy. And is it only your position being eliminated? Is it many people losing their jobs here? So there's that particular question, but they have to put you back, and if they don't, it's in your position or something comparable, it's a human rights violation. So at minimum, you have that. Human Rights Tribunal has exclusive jurisdiction in British Columbia, and I don't know where you are, and it has it's very behind because it's under resourced. So, or we'll just say it's very behind, and so it takes approximately 4 years for a matter to get resolved. But nonetheless, you'd certainly have a complaint through there for lost wages and perhaps injury to dignity. However, if your contract didn't limit you in any way, I'd probably treat that as a termination. So you can't do this without talking to a lawyer, but I wouldn't take any action whatsoever until you can talk to a lawyer. But I personally, if you were my client, I would, and depending on the circumstances of your contract, I would probably just say treat it as a termination right away and then proceed in a severance claim against your employer. They have to put you back, and they're not for their own financial reasons. They can't extend your medical leave if you're ready to come back to work. So I think there's potentially a lot of different things you can do there strategically, Marta. So I would talk to an employment lawyer right away. We're coming towards the end of the broadcast, so I'll hold off giving the information, and we'll just give it to you again on how you get a hold of us. But certainly, Marta, you want to talk to an employment lawyer right away. Okay, this individual's name is quite funny, but I'll just call this person T. I signed an employment contract 10 years ago with a U.S. company, but I'm employed and paid by their Canadian company. In Ontario, I know there's a ban on enforcing non-competes, but I am not sure if that would be in effect since the agreement is with a U.S. company. The contract signed states I cannot compete for 12 months following the resignation. I don't know what your question is. Are you asking if it's enforceable? We talked about non-competes earlier in the broadcast about, they're unlikely to be enforceable, generally speaking, depending upon how senior your position is. The higher up your position is in terms of authority and exposure to trade secrets and insider information of the business, the more likely it is to be enforceable. But generally speaking, non-compete clauses are unenforceable for a variety of reasons, but the underlying policy, public policy, rationale and dynamic as to why they're unenforceable has to do with, listen, if the only thing you know how to do is, again, I go back to the same example, but if all you know how to do is make widgets and you have a mortgage and multiple kids, I mean, I know everybody's different. I'm just using it as an example. It's not good for society if now you're prohibited from making widgets for 2 years. What are you going to do to feed your family, pay your mortgage? It's not in society's interest if you default on your mortgage and you can't feed your kids. And so for those reasons, for rank and file employees, on almost all employees, non-compete clauses are going to be most likely enforceable for one reason or another. But again, in narrow circumstances, like if you're really concerned about this, the higher up, particularly if you're in a very elevated position at your business, certainly talk to a lawyer one-on-one to go over your specific non-compete clause. Your question is, you have an interesting situation. So you work for, so you're employed and paid by so this happens quite a bit. You're employed and paid by the Canadian company, but who gives you orders? It's the American company. And so, it sounds like those two companies are common employers for you. Is the non-compete enforceable? Well, who's your employer? It sounds like they both are your employer. I'm less jurisdictionally worried about that than I am, the fact that generally employment non-compete clauses are unenforceable, and I would probably take that route. But it sounds like you're imminently contemplating a move anyway. That's why you're asking that question, but it's not particularly clear. But I think it'd be worth it for you to have a lawyer take a look at the non-compete clause, the contract, etc., and assess whether or not it is in fact enforceable. Okay, last question by Lily. If an employer lays you off before a commission pay period, are they allowed to withhold that payment? How long can they keep me on layoff? Okay, let's tackle the second question. So what a layoff is it's a temporary interruption of your employment with the general idea that at the end of the layoff or sometime before the end of the layoff, you're going to be brought back to work. And that's the whole idea of what a layoff is. And so generally layoffs occur because the business doesn't have sufficient cash flow to pay you at this specific time, generally speaking. And so, but you want to maintain your job there, and the employer wants you to be an employee still, theoretically. Now, under various Employment Standards Acts in British Columbia or in Canada, after a certain period of time, your layoff becomes an automatic termination, and so in BC it's 13 straight weeks or 13 out of any 20 weeks. It'll be different in different jurisdictions. It becomes a termination. It's an open question if that's a termination for all purposes or just for the Employment Standards Act, as opposed to also for big severance, for common law severance. I've always thought the idea that you can have a termination for one thing and not for another to not sit easily together, but the law on that is a little bit confusing and in flux in British Columbia, but I don't know about its treatment in other provinces. But generally the idea is if you choose to enforce it, the Employment Standards Act, if you're provincially regulated, or the Canada Labour Code, if you're federally regulated, can terminate your employment after a certain period of time, and why would you want that? So you can pursue severance remedies. Okay. Now, your question is, if an employer lays you off before commission pay period, are they allowed to withhold that payment? I wouldn't think so. I've never considered this question, but if you have trailing commission that's entitled to you, I mean, if you're on layoff, you're not getting paid, so it's an interruption of your pay. So I'd have to take a look at your employment contract. I know that a lot of employers do something really sneaky with commissions. So what they do is they say, well, in your employment contract, here's a termination clause that goes for a certain period of time. We're going to pay you commissions way outside of that. And by the way, you have to be an active employee in order to be paid out your commissions. So the idea is they can fire you if you have a bunch of commissions coming to you and not have to pay you the commissions. I've always thought that was, from a fairness and justice perspective, to be wildly unfair. And it's something, because I know businesses do that on purpose. And when there's big sales with big commissions, rather than pay out the commissions, some businesses will just terminate the employee. So the employee can't get the commission, which is guaranteed to that employee under the contract, and may be the reason why that employee signed up with that particular employer in the first place. And so I think that at some point, with the right fact pattern, that particular problem will be addressed by a court somewhere in Canada. But that doesn't answer your question. Are they allowed to withhold payment of commission during a layoff? And I must confess, I don't know the answer to that question, Lily. I would look at the four corners of your contract. Intuitively, I want to say no, but I can see why they might be able to, depending upon what your Employment Standards Act says and the contract says, because your pay is interrupted. But it seems materially unfair. So if it's a substantial amount of commission, you may want to talk to a lawyer. My information's on the screen now, not mine, ours, employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. If we're talking about $1,000 or two, probably not worth it. If we're talking about $60,000, certainly worth kicking the tires on, and I recommend you talk to us or another lawyer, and just get someone to look into that. But certainly look at your contract as well. You're welcome, Lily. Appreciate the nice note. Okay, we have. I'll be back in 2 weeks, I believe. Same time, 10:30 a.m. Pacific time, Friday, 2 weeks. Join us on Monday if this hasn't been posted already. I believe it's Chris Justice, 1:30 p.m. Eastern time. He'll be explaining all things about employment law then. Other than that, great questions today. Thank you for getting them all in. I wish you a safe and wonderful weekend.